everyone. This is Poonam Harjani, leader of Taxman's Advisory and Research Support Services. Honorable Supreme Court's ruling in the case of Northern Operating Systems. This ruling has been much talked about, debated, and has been in controversy for the last several weeks. Honorable Supreme Court in this ruling has held that the employees that are sent to Indian entity by an overseas entity and the payment with respect to such employees is made back to the overseas entity are liable to be taxed in the hands of the Indian entity under the service tax regime on reverse charge basis. This ruling relates to the service tax regime, as I said, however, continues to hold relevance even with respect to the GST regime. And therefore, we have come up with today's analysis in which we are going to discuss the key observations and findings of Honorable Supreme Court in this ruling and expressing our take on them. Let me start with sharing the slides. In the analysis section of the ruling, the Supreme Court starts off with a statement that the crux of the issue is the taxability of the cross charge, which is primarily based on who should be reckoned as the employer of the secondee. If the Indian entity is treated as the employer, the payment would in effect be reimbursement and will not be liable to tax. However, in the event the overseas entity is treated as the employer, the arrangement would be that of a service and will be liable to be taxed. Friends, this conclusion arrived by the Supreme Court is absolutely accurate. And indeed, the whole matter depends on who is to be considered as the employer of the person sent on deputation. While the Supreme Court has examined multiple aspects, various clauses of the agreements, the facts under consideration, however, one important aspect that's missing from the ruling is for the Supreme Court to examine or comment on whether the concept of contractual employer versus economic employer is relevant to determine taxability here. Friends, internationally as well as under Indian income tax law, the concept of economic employers is fairly evolved. Now, whether that concept has to be applied here, and if not, then why not, is not commented upon or elaborated in the ruling. In the OECD, in its commentary on the Model Tax Convention, has given an elaborate explanation on the taxability from a direct taxation perspective under various scenarios. Now, while the commentary is international and it is well acknowledged that it doesn't relate specifically to indirect tax regime, on principles, it's not clear why that commentary does not hold good with respect to indirect tax as well. The commentary talks about a specific possibility that even if there is no formal arrangement between the recipient entity and the employee, even then the arrangement could be that as that of a employer and employee between the recipient entity and the employee, and the taxability is to be determined accordingly. There are a whole host of illustrations and scenarios discussed in the commentary, and had the Supreme Court taken note of these guidelines, it is possible that the conclusion arrived at by the Supreme Court may have been different. The Supreme Court has also looked at very closely at the manner of disbursement of the salaries to the employees. And it went on to say that it paid the amounts equivalent to salaries to seconded employees has two consequences. One, that the seconded employee continued to be on the payrolls of the overseas employer. And secondly, since the employee was performing job not with respect to the employer's business, which is the overseas entity, but that of the SSE, which is the Indian entity. Therefore, the SSE had ultimately borne the burden of the costs. Friends, with this statement, Honorable Supreme Court has effectively concluded that by taking on the responsibility to pay the salary, the expatriate has to be considered as to be on the payrolls and thus the employee of the overseas entity. Whereas what is there in the agreement explicitly in this case is that the role of the overseas entity is restricted to be that of a payroll service provider merely by making the payment of the salary. The overseas entity does not acquire the status of the employer of the person under deputation. Further, the Supreme Court has also taken note about, commented upon the relationship between the concerned entities. And the court said that it is not concerned with unraveling the nature of relationship between the overseas company and the SSE. What is important to be decided here is that for the purposes of completion of SSE's job, whether the secondment amounts to manpower supply. Friends, we have a difference of opinion here with the Honorable Supreme Court because Honorable Supreme Court has wished to appreciate the fact that in order to for the service tax or currently the GST to apply, the relationship of the service provider and service recipient between the two entities has to be established. And unless such a relationship exists, there can't be any liability of service tax or currently GST in such situations. There are certain findings which are, in our view, irrelevant for arriving at the conclusion that Honorable Supreme Court arrived at. Honorable Supreme Court has said that the letter of understanding between the SSE and the seconded employee nowhere stated that the later would be treated as former's employee after the seconded period. Friends, it is inconceivable that the letter of understanding would ever say that the seconded employee will continue to be the employee even after the seconded period. So therefore, this statement and finding is not a relevant finding which has any bearing on the conclusion arrived at. And also, what happens post the completion of the contract term is also in our view an irrelevant fact to determine the taxability during the relevant period. Moving on, we also noted some of the findings in the ruling contradicting each other, and we would like to highlight one specific aspect here. In paragraph 50, Honorable Supreme Court, in the highlighted bold underlined portion, if we note, the Honorable Supreme Court said that they, meaning the employees, were not performing jobs in relation to employer's business, which is referred to as the overseas entity. So the Supreme Court is here acknowledging that the employees were not performing jobs in relation to the overseas business. And further going down the lane, under paragraph 57, Honorable Supreme Court says that the fact remains that their overseas employer in relation to its business deploys them to the SSE. Now, these two statements are on the face of it contradicting each other. And hence, it's not clear whether the Supreme Court considered the fact that the employee on job was performing the overseas entity's job, or was it working in relation to the Indian entity's work. There is also an incorrect finding in the ruling, which goes on to say that in terms of the employment, even during the secondment, the terms of the employment, even during the secondment, are in accordance with the policy of the overseas company who is their employer. Friends, this finding is patently incorrect because the terms of the agreement categorically said that the terms and conditions of the employment with NOS, the Indian entity, as stated in the agreement between the employees and NOS, will remain in force during the secondment period. All terms and conditions of employment with the overseas entity will cease during the secondment period. So hence, the finding arrived at by Supreme Court is contrary to the explicit contractual terms. Right, further, some of the statements and observations made are kind of non-specific observations in the ruling. The Supreme Court has said that what is unsaid, left unsaid, and perhaps crucial is that it is a legal requirement since they are entitled to social security benefits in the country of their origin. It is also mentioned that it is doubtful whether, without the comfort of this assurance, they would agree to the secondment. So, from the very verbiage, the language used in these paragraphs, it is clear that the statements are, these are mere statements of uncertain facts. These have not been examined for their reality by Honorable Supreme Court. And furthermore, friends, even assuming that these facts were to be real, what needs to be examined is whether these facts would lead to absence of employer-employee relationship between the Indian entity and the concerned expatriates. On the aspect of revenue neutrality, Honorable Supreme Court has not placed reliance on two of the orders in the case of SRF and Coca-Cola on the ground that these were mere CSTAT ruling without any independent reasoning by the Supreme Court and thus do not have precedential value. Friends, on this aspect, in our considered view, Honorable Supreme Court has mixed to examine and comment on the doctrine of judicial merger to conclude on whether these rulings will have precedential value. We'll talk about this aspect in more detail in the next slide. The Supreme Court has also noted that the Supreme Court is also of the view that for similar reasons, the orders of the Supreme Court were affirmed by the court in case of Volkswagen and Computer Science Corporation are unreasoned and of no precedential value. Why these two orders, Volkswagen and Computer Science Corporation, we agree, did not have a precedential value. We would want to highlight that there was another Supreme Court ruling in case of Nissin Brakes that was also relied upon by the SSC. And that ruling was indeed the Supreme Court had admitted the appeal against this, the revenues appeal against this ruling, and later on dismissed the revenues appeal after admission. And as such, applying the principle of judicial merger, the ruling in case of Nissin's Brake was indeed a Supreme Court ruling. And friends, it is important to note that Nissin's Brake Supreme Court ruling is a two-bench judgment, whereas in northern operating systems, there has been one Supreme Court judge. So applying the judicial hierarchy, the Nissin Brakes ruling has a higher precedential value. Friends, I want to draw your attention to the Supreme Court ruling in the case of Punaya Ahmed versus State of Kerala, and in which, while deciphering on the doctrine of judicial merger, Honorable Supreme Court has concluded as follows. It says, Once a special leave petition has been granted, the doors for the exercise of appellate jurisdiction of this court have been let open. The order impugned before the Supreme Court becomes an order appealed against. Any order passed thereafter would be an appellate order and would attract the applicability of doctrine of merger. It would not make a difference. Friends, I invite your attention to the last part of this ruling. It says it would not make a difference whether the order is one of reversal or of modification or dismissal affirming the order appealed against. It would not make any difference if the order is a speaking or non-speaking one. So the short point, both on the aspect of revenue neutrality as well as with respect to the precedential value of Mrs. Drake's case, in our view, the conclusion arrived at with respect to the rulings not having precedential value, we beg to disagree with with the finding. Finally, friends, the Honorable Supreme Court has relied on the income tax ruling in case of Morgan Stanley, and where the Supreme Court earlier had said that it is important to note that where the activities of the multinational enterprise entails it being responsible for the work of the deputationists, and the employees continue to be on the payroll of the multinational enterprise or continue to have their lien on their jobs with the multinational enterprise, a service PE can emerge. Friends, in our view, the Supreme Court has not appreciated the fact that in Morgan Stanley's case, the Supreme Court arrived at the conclusion of existence of a service PE based on two facts. One, the overseas entity is responsible for the work of the deputationist, and secondly, it continues to be there on their payroll and to be and to hold lien on the employment. And this fact has not been acknowledged and considered by the Supreme Court in Northern Operating Systems case. So finally, coming to the conclusion, friends, there are as we've seen, there are several legal aspects in the Northern Operating Systems ruling that need to be re-examined, and therefore, in our considered view, the ruling merits review. The conclusions arrived at are very fact specific and will not apply in all cases of overseas expatriates arrangements. And while the positions taken by the companies after due analysis should not get impacted due to this ruling, it's still useful to examine the inherent risks in the current contractual arrangements with respect to expatriate employees. And finally, the impact, if at all, on any income tax from an income tax standpoint is also worth examining. Friends, that's all for today from my side. Thank you so much for being with me on this video. And I thank my colleague team, Sunil and Yamini, for supporting me in preparation of this video, and our marketing team in finalizing the video. Thank you so much. Do not forget to log on to www.taxman.com/advisory to know more about our advisory services. Thank you very much and have a good day.